Hi, it's Harpreet Singh from Western Singh Law Firm. Today I want to discuss with you about covenant not to compete. As the name sounds, covenant, what's that? Probably I think some of you already know about it, but people who don't, I think, regularly deal with documentation and things, so probably they don't know about it. So basically it means a promise not to compete. You are making a promise that you will not be in a competition with some other person who you providing this promise to, in exchange obviously for some other gain. So this covenant not to compete, let's move to 1800s. So in those times, these kind of promises that you will not compete or you will not perform certain business activities, that was allowed in kind of a broader way, but there was a standard about that any kind of those provision needs to be reasonable. And we will understand, I think, reasonable in a moment, what is mean by reasonable and what is not, and how you can and look that and try to judge it. So those things were allowed previously, but then legislature, as time goes on and we were going through the industrial revolution, so the legislature have taught, means as a society we want people to perform activities, we want people to put best of them in this market economy, because market economy, as you know, it's all about competition. So legislature and also the society as a whole thought about that we should not restrict competition in any kind of way, even through agreements. So the legislature, through Business and Profession Code 16600, just came with an idea that any kind of provision in any kind of agreement which will restrict your skill, performance of any kind of business activity or any kind of trade will be prohibited. That's just full stop. It would not be allowed even if you are in agreement. That means the other side, who would be probably gaining benefit of it, would not be allowed to take advantage of that provision and just go to court and request the court that this provision should be enforceable and this person should be stopped in some kind of through some kind of injunction. So that has become a public policy from long time, and there is a statute and also case law around that. So let's see, I think one of the examples so you can better understand. So one of the example would be your employment contracts. Because in old times, employment contracts, you can restrict employees that after, okay, you have worked with me for a number of days, years, so you should not be able to work out and open your own business and just perform the same activities, because obviously you would have concern that the employee have gained certain knowledge and also exposure to certain customers, clients. So now he or she can become your competitor. So in old days that was allowed, but obviously with this, I think public policy in mind, so it's not allowed. It's very strict in employment laws. You cannot restrict your employees from being your competitor. Again, the idea comes in, it's good for society to have competition in place. So even if you have in your employment contract, you should just remove those clauses, because those clauses are unenforceable and it would not work out. And if you have so much of other things in your contract which is unenforceable, which will obviously irritate the court, what you are doing, what kind of relationships you are creating, just violating public policies. But the second example I think I'll like to give you, it's about probably if you have dealt with, I think, sale of a business. You just enter into contract with the seller, because you are paying seller the money, that you want the seller not to become your competitor. And that's, I think, reasonable and very logical in any kind of business dealing, that you don't want those kind of people to be around just I think getting customers in, and so probably you will lose the revenue in future. So that's the general rule. And it's really important to understand the general rule. It's broad prohibition on any kind of provision in your contract which will restrict people to not perform certain business activity, operation, or any kind of skill or trade. However, there are exceptions, and these are like very narrow exceptions. These are just for a set of business activities. In general, you cannot restrict people, means to perform any kind of activity, but in like a business sense and also in transactional sense, you can restrict people to perform or not to perform any kind of business activity. However, as I move forward talking about these exceptions, one thing you have to keep in mind that the main standard which these provisions will be looked through is the reasonableness standard. So reasonableness, what is mean by reasonableness? Anything can be reasonable. Reasonable can be different for different people. Obviously, it's a fact-intensive inquiry. It's mostly objective in nature, means court will look, okay, what a reasonable person will do in this certain kind of situation. And as we have just discussed, a reasonableness in a situation of a business sale, you are purchasing a business like a convenience store, and you obviously want that the seller should not be able to open after my close of escrow just a similar convenience store just down the road, because you are paying money to that seller, and obviously you expect that I am giving you value and I am basically purchasing your reputation and all the assets. So you should not compete with them. And also legislature understood that. Because of that, they have created all these exceptions. So let's move forward and work out through different exceptions we have. So first is the sale of a goodwill. If suppose you are in a transaction where you're purchasing goodwill of a business, and obviously in that situation, it's logical to have those kind of restriction that the seller would not be able to, for certain number of years, certain number of miles, that the seller would not operate a similar business. And again, this reasonableness will come, because it's reasonable to have that provision, but how much narrow that provision needs to be, it would be dictated by this reasonableness standard. You would be thinking about, okay, why cannot I have a agreement where I would have a blanket restriction that, okay, you will not operate a business like this in this county for like 10 years. That's kind of a blanket restriction. Again, when there would be a dispute, if seller opens such kind of business and you will have a dispute, and the seller will object to that provision and say it's not reasonable. Our main purpose to restrict my competition, it was because you have paid that value, and these kind of certain businesses like convenience store or restaurants, these are location specific for certain extent, especially convenience store. So if you're asking me not to open a business like in the whole county, which is about in a radius of, for example, 100 miles, that's unreasonable, because it will not, I think, perform any kind of competition with you. Because in industry, it is said that a convenience store, the other convenience store have like a normal one, there can be some exceptions again, like 2-3 miles of range. If there is a convenience store after 2-3 miles, it's not basically creating any kind of competition. Obviously, there are different factors. Its location, if there is only one convenience store in that whole town, then it would be a different thing. Obviously, then that whole town becomes, so you are becoming kind of a competition. It's also it also depends on the distance, your location, the reputation of business, what kind of product you're selling. So including all these factors, then you would decide what's reasonable in this situation and what's not. So obviously, sale of a goodwill of a business, that's allowed, but the provision needs to be reasonable. And I think traditionally it has been for certain number of, especially for retail business sale, it has been 5 years. So those are just rule of thumb, 5 years for 3 miles, 5 miles. It just depends on the business. So let's see the next exception. So the next exception is also similar. It's in addition to the goodwill if you are purchasing any kind of operational business asset of a business. So you can enter with the seller in a restrictive non-competition agreement that the seller will not compete with this particular and similar business, and again that reasonable standard will apply. Let's move forward towards some of the restrictions which are applied not in the whole asset sale of the business, but even the sale of the shares in the business. For example, you are in a partnership and you want to sell your interests to the other partner, or you just want to disassociate with this partnership or just dissolve this partnership. In such a situation, the both sides can enter into a non-competition clause, which would, again, it needs to be reasonable. It depends. If you have a manufacturing business, again, the range would be, I think, little broader, because there are not whole lot of manufacturing business. If it's maybe a medium-sized town, probably there are 2-3. And what would be the range? It just depends on the parties, and again, it needs to be reasonable based on your business activity. And the next thing, same thing with the LLCs. If suppose one of the member in the LLC is selling their interest to some other member, or they are just dissolving this LLC, in that situation, two partners can have an agreement that you would not compete for certain business activity with him or her. And because in all these situations we have seen, there have been money exchange, and actually value have been paid to restrict that activity. However, still you have to understand, in employment side of it, it's completely restricted. But I'm not saying you that your employee can steal your trade secret. That's a different thing, and it needs its own series of videos, because again, it's a very detailed topic. So in that situation, obviously you have different avenues to perform, to take action, but with the employment, it's very restricted. Means you cannot have any kind of agreement with your employee which will restrict their activity to perform certain business, trade, profession, or any kind of other activity which would be economical in nature. Or even like a normal act, you cannot restrict a person to say that, okay, you will not travel so and so country, because that doesn't seems to be reasonable based on whatever activity you would be doing. So thank you for watching this video. In the next video, I would be just bring new topic. And again, thanks for your comment, your appreciation about these videos. Main purpose is always to educate about and about different kind of, I think, laws, provisions which you have to deal with in your daily lives, and to give you little glimpse of what the generalized laws say about it. And obviously every case is specific, so you should consult with a legal professional and just evaluate what's going on in your whole situation. Thank you.